for example, people can post anecdotes about processing times on online forums, but that's not within the spectrum of really what is substantive legal advice. So, by contrast, today is more in terms of the scope is uh, giving some kind of direction, so as to not have you be wasting time on a program or spending money, for example, maybe considering tuition at a school or something expensive like that as a potential pathway for permanent residency. So, with that sort of context in order, I want to just maybe invite people to, um, well, type it in to please pose questions in the chat, since I believe by default you're muted, right? So that's what the kind of scope would be. So, and these things tend to come in sort of pointed questions. Sometimes there's follow-up questions, which is fine as long as my brain can track which question is related to which initial question, because sometimes, because it's a group chat, there may be questions which are follow-ups to questions which were previously posed. So it may take a little bit of thought process on my brain to recontextualize the whose follow-up question pertains to whose initial question. So, but with that in mind, let me look at the first question. So the question relates to an outside of Canada family class sponsorship for a spouse. And as is the norm, an acknowledgement of receipt is received, issued by the immigration department to the sponsor and often to the applicant as well at a later stage. And the question is, can we apply for a visit visa for her while the PR application is being processed? So the short answer is yes. There was a program which in fact is supposed to allow people who are outside of Canada awaiting their spousal or common law application for permanent residency to be able to apply for even a work permit while they're outside of Canada. So the issue is, has this actually occurred? We've come across people who have tried this and they were simply met with delays in processing for the work permit. Delays, in fact, that exceeded the processing time of their spousal outside of Canada application. And in one situation, we've encountered a case where the permanent resident case to sponsor the spouse was approved. And I believe 2 weeks later, the work permit was approved, which of course has no meaning because the person is already a permanent resident of Canada. So that's one option. And the strict phrasing of the question was, is a visitor visa possible? And the short answer is yes, a visitor visa application is possible while your outside of Canada spousal or common law application is pending. The processing time might be shorter depending on the country the applicant seeking the PR or permanent residency hails from, and it might be a good strategy. The idea is that you have to satisfy the officer that if the visitor visa is approved and if the person does come to visit Canada, you must address the what if situation, namely, what if the permanent residency case is denied? Will the person on the visitor visa, the spouse who was being sponsored, satisfy the officer that they will leave Canada in the event their PR is denied? So what you could infer from that, if you have a strong intuition, is that sometimes the likelihood of success for the visitor visa application in some cases could be tied to the prima facie or the ostensible strength of the relationship as presented in the outbound Canada PR application. Because If the officer sees there is a strong foundation for the PR to be successful, then the risk of the person being motivated to break the law about being a visitor would be low, because it's kind of a proverbial slam dunk or high chance of success for the PR. So that's something to keep in mind in terms of the context for the question. Can you apply for can you apply for a visitor visa while an outbound permanent resident case is in process? So with that, I presume I've answered the question. I'll just take another look at the next question. So another one looks to be related to marriage again. So it indicates that there was a marriage in Canada, and the plan is to sponsor the newly married applicant. The spouse/applicant lives in Canada and entered Canada without the requirement for a visitor visa. In other words, from a visitor visa exempt country. And the question looks like a very pointed question in this context, which is, when applying, the immigration department asks for status of the applicant. So the status for that applicant is what? That is the question. So the context of this would be filing an inside of Canada spousal application because they're married. And when you arrive at a port of entry from a non-visitor visa requiring country, the most you have to do is an ETA, which you do before you get on the plane. And then you arrive at the port of entry, presumably as a visitor. I'm inferring in this case because there's nothing about a work permit. And the port of entry officer, has one last opportunity to question, or in immigration parlance, examine you in relation to the criteria that you are entering. So even non-visitor visa people could be subject to some scrutiny. It sounds like this person was not. I mean, they could maybe add more context. But in that situation, the default, when they let you in terms of what your status is a visitor. And unless they write something in your passport and or tell you something explicitly, then the amount of time you're allowed to be a visitor is 6 months from the date of that entry. So with that sort of contextual answer, the short response would be a visitor, unless I get more facts which maybe make the case more complicated. But with that in mind, I'll proceed to another question in the chat, right? So the question relates to what our firm does. So does it do visitor visa applications and the charge for visitor visa applications? So one question which I noticed was in that question I just asked was that there was a history of a refusal. So the short answer is yes, our firm does do visitor visa applications, and we do process visitor applications for Canada that were refused. And in fact, anecdotally, that tends to be the pattern because, as you may know, if you look at Canada's immigration website, they try to make it full of information and try to make available everything to do the application, including document list, forms, client-specific portals for things such as visitor visas. And given that structure and that level of comprehensiveness on Canada's immigration website, people do make an application for a visitor visa on their own because it sort of looks straightforward, although it's not. And I think the sort of general thrust of Canada's immigration website in this regard is that they're assuming every candidate is a perfect, flawless candidate that has no unusual history, does not fit any kind of negative profile, such as traveling to a country in a certain way or being associated with maybe a governmental organization or maybe has had a travel history. So when the immigration department is encouraging you to do an application yourself, they're presuming all the cases are very straightforward. But on the other hand, especially with visitor visa applications, if there is a point of concern that the immigration officer has, such as whether the person has a lack of travel history or a lack of strong connection to the person they are going to visit in Canada, or a lack of a strong financial obligation in their home country, this no longer becomes a straightforward visitor visa application. And if you file or self file a visitor visa application in that kind of situation, without addressing the peculiarities, which you may not know unless you're experienced, the likelihood of success would be lower, unfortunately. So, those are the things we keep in mind in the case where a visitor visa was previously refused. And we obviously try to get the application forms. In this case, it would probably be from a portal because they tend to be in portals. So, we would try to get the screenshots of that to ensure consistency and make the occasional corrections. Some people make minor mistakes in those situations. And the market price, I think, from what I hear for experienced immigration lawyers is about 2,500. It might be less. Um, if it's an experienced lawyer, that would probably be the price, or more, right? By contrast, I mean, just for the sake of completeness, because we try to give a comprehensive general answer to these questions. So, in theory, you could look for a licensed immigration consultant sometimes, but not always. Sometimes they are less expensive than lawyers because, from what I understand, their insurance requirements are quite a bit less than ours. And if you come across any lawyer or consultant who's experienced and offers a price that suits your financial circumstances, then that would be the way to go. So, with that question, I think disposed of, let me see if there's anything else, right? Let's see. So now we see there's a question relating to when applying for the in Canada class, can the applicant leave Canada while the in Canada permanent resident spousal application, I'm going to say, is being processed? And can they come back on a later day while waiting for the PR approval? So I want to make sure I understand. I mean, the simple part is, can you leave after you file the inside of Canada spousal application? Technically, no. The law says that you cannot leave. That being said, if you have to leave for a temporary purpose, like an emergency or a family member's emergency that's connected to you, you could probably safely leave as long as the amount of time is not too lengthy. But that's on the face of it, the officer is not following the strict letter of the law. So I always point this paradoxical situation where the law is not always followed by officers. It's probably because with the amount of people entering Canada and the need to process their entries quickly, an officer, practically speaking, may not know that the person has filed an inside of Canada application. Mind you, the amount of scrutiny is higher if you hail from a visitor visa requiring country where you do get examined, tend to get more examined in more detail, and then they could ask you, have you ever filed for permanent residency? And then if you say yes, this could trigger a series of questions and may lead the port of entry officer to contact the immigration department and ask them to investigate this in the context of the already filed inside of Canada spousal application. So I hope that gives enough context to that question. And so with that in mind, I think I disposed of that at the moment. So in these types of situations, we like to, in the context of a consultation, we try to get the relevant facts about the reason for the person leaving Canada? And does it fall into some kind of exceptional situation that may elicit some sympathy by the port of entry officer in the event you do have to leave and then come back? Another situation is sort of on the same question, is if you are leaving for a longer period of time, then what's the state of the relationship with your sponsor? This could lead to the concern that the marriage is not genuine and lead to the either triggering of an interview or maybe even the outright refusal of the application if the officer follows the strict letter of the law. So it's something to keep in mind. If there's a real dire need to leave, you may want to get like formal legal advice where we can get the full context of what the circumstances are. But obviously, that would be have to be a serious kind of matter to leave, because the structure of the law is that they want you to stay. They can even allow you to file for a work permit if you have a inside of Canada spousal application, to try to make your transition to life in Canada smoother, because then you're entering the labor market despite not having the permanent residency. So that gives you a clue about the priority they ascribe to the inside of Canada applicant for PR as a spouse remaining inside of Canada while their spousal PR application is in progress. So with that being said, I'm wondering if there's any other question. No, so not a whole lot. So in these types of situations, sometimes we have lawyers and consultants who join the webinar and ask a very technical question relating to usually delay or, on the other hand, enforcement. So I don't seem to see that here, at least not this time. But with that being said, I see something else here. So a spouse who has an outside of Canada sponsorship, which is under process, and a visitor visa can be applied for, and the work permit. So then, given those two options, the question is, does the visit visa application have to be done first? And once the TRV is approved, then apply for the open work permit. The answer to this is basically you apply for one or the other. So because there is enough specificity in the application that you can choose one when you're applying for the temporary resident visa. You'd have to cite the policy, which I believe came out in May 2023. I think I'm correct about that, which should trigger in the mind of the officer the obligation to assess as a TRV with a work permit option, as opposed to a standard TRV, which is just to visit and enter Canada for the purpose of visiting and getting a visitor record at the port of entry. So either or is the short answer to recap the question for that. So in these cases, it brings to mind one other situation, which is people who are in a relationship and they're not married, but they're in a serious enough relationship, and the person is from a visitor visa requiring country and files the visitor visa application, but does not disclose that they may have lived with the person who's Canadian that they're visiting. And that could lead to an issue down the road where, for example, if the visitor visa application is approved and you enter Canada and then you get married, and then you file for permanent residency. And when you file for permanent residency, you include your address history. And if the officer says, or observes rather, that you lived with your Canadian girlfriend or boyfriend, as the case may be, for 1 year, and did not declare that on your visitor visa application, that could be a grounds for a material misrepresentation. And that could lead to not just the Section 40 5-year ban from Canada, but that could also prevent you from ever being sponsored as a sponsored spouse. And the alternative would be to try to file under humanitarian and compassionate grounds, which is highly discretionary, and it's the type of thing which you'd want to get legal advice about. So that's sort of the worst case scenario that comes to mind, which is not necessarily what's being posed here, but it's something we come across from time to time with having to deal with through humanitarian and compassionate considerations. Again, a very discretionary remedy to something which may have been avoided if there was some legal advice about coming to Canada as a visitor in the context of an already well-established relationship, such as a conjugal or common law relationship. So, that being said, I think there's nothing else in the short term for this. So again, any other questions, please feel free to pose them in the chat. And the other sort of general idea that people should know about immigration law is that, for example, this whole idea about being able to apply for a work permit while an outside of Canada spousal application is in progress is what we call I would characterize as a creature of policy. So policy in the context of immigration law is part of a hierarchy. So on the one hand, there's the law, the Immigration and Refugee Protection Act, which is binding on officers. And then there's the regulations, the Immigration and Refugee Protection Regulations, which is also binding on officers, but is a bit more broad in scope. And then there is policy. So this idea about being able to apply for a work permit while you're outside of Canada case is pending is a policy. So they announced it. Now it's open. It's subject sometimes to time limitations. Sometimes annually, they have to announce that they're going to renew the policy in some cases. And sometimes it's also subject to specific terms and conditions, the effect of which may be binding on an officer, despite the fact that it's a policy. So we see that in the immigration context in many situations. And I think it's unique to Canada's laws that the immigration laws have lots of policies which amplify or dilute the types of programs embedded in the law, such as expanding work permit opportunities, right? Or in the recent past, using policy to narrow the scope of things like study permits, where now the eligibility for a work permit is restricted unless you are going to enroll in a master's or a PhD program. Before January, you could apply for a study permit at a 2-year publicly funded college and get the application for the work permit for 3 years after 2 years of studying and graduating. So again, policy is just shunted and truncated that policy very suddenly. Doesn't affect people who are already here on the study permit. So those people who are not in masters and above programs who are already enrolled in a publicly funded college or university could still apply for the work permit. So this is another example of the impact of policies which come and go, which puts the burden on us, immigration lawyers, to look at the policies and have little alerts for those things so that we're ready when clients have these queries about the brand new program that relates to permanent residency in some obscure part of British Columbia, for example, such as the Rural Northern Pilot, a very obscure program, which we have to sometimes find out about for the purpose of apprising clients of other possibilities for permanent residency, despite not having, for example, a good expressentry point score, or perhaps not having the requisite amount of English language skills. So that means we have to be on the ball about all these broad-based policies, and they keep changing. So with that in mind, I don't see any further questions, so feel free to pose any other questions at this juncture. So in the other situation I'm thinking about, when I looked at the scope of the questions thus far, things like uh, family class applications, anecdotally, it seems that there tends to be less interviews for the inside of Canada spousal applications as opposed to the outside of Canada ones. That may be because there is a period of separation, namely the processing time for the outside of Canada applicant before he or she can come to Canada. So if there is a delay in processing, sometimes what happens is perhaps more than a year has elapsed since the processing. And the question is, what if the sponsor did not visit the applicant while the PR is in progress and more than 1 year has gone by? In the mind of the officer, this could be motivation or justification to convoke an interview. That, along with the types of photographs and history of the relationship that's been presented. So, for example, if the photographs don't show a celebration with many people, or they just look odd in the officer's perspective, that could trigger an interview. If there is something related about the development of the relationship, for example, merely going to a foreign country and meeting the would-be spouse and getting married after 3 weeks, that could trigger an interview because the officer may have the concern about whether the person properly did their, I hate to use legal words, but did their scrutiny, for lack of a better phrase, for the purpose of assessing compatibility with the prospective spouse. And that could trigger an interview, in other words. So the odd situation sometimes, rather, is that there is a quality assurance component. So sometimes you're randomly convoked for an interview, or you're convoked for an interview perhaps to train an officer about interviews. And they see if there's a genuine one, then it might be something worthwhile to train an officer in for these cases. That's what I've heard, at least. And that's just the receiving end. Then you're just a victim of bad luck because it tends to delay things a little bit, because the interview has to be conducted and recorded, not audio recording, but rather just typed out. And then the assessment has to be made. And then the later success stage of requesting the passport, etc., is given. So it's like an additional bump in the road when you have to have an interview in the context of a spousal application. So with that being said, I've tried to give a bit more background about some of these sort of background issues related to the questions already posed. With that in mind, I'll take another look to see if there's anything else, right? So the question is there any way for people who cannot get a job or qualify under express entry to immigrate to Canada? So the short answer is if I set aside family class, where you don't have to know English and you don't have to have any particular skills, if we exclude those cases, then yes, you have to have a job or a job offer, or you have to qualify under express entry or one of the myriad provincial nominee programs. But when you look at the requirements for a provincial nominee program, they're job offer based. So they have, for example, in the prairie provinces, occupations under pressure. And that means you could be subject, if you happen to have the skill, you could theoretically qualify for permanent residency, excuse me, outside of the express entry system, because Saskatchewan has for candidates outside of Canada its own point system, but it's very narrow. And it favors language still, and you obviously have to have that particular skill, which again is not maybe not necessarily a job offer, but you have to have a certain skill. And theoretically, it might be easier than express entry if you happen to have the job skills that they're looking for, the requisite language skills. But more importantly, you have to satisfy them that you're going to reside in that province. So that would take a little bit of expertise to show. I mean, one significant component of that could be that your particular job is in demand more so in Saskatchewan as opposed to other provinces. And research could be canvassed about that to help convince the officer that you will in fact live there, because they have discretion to refuse these types of applications for these provincial programs if they don't think you're going to reside there. So in other words, if you have a relative in another province, you may want to explain that. Otherwise, the officer may use their discretion to refuse the application on the basis that they're not satisfied you will reside there as a permanent resident of Canada. So that's the short answer to the question. Yes, is there something outside of express entry or a job offer? So it's basically skills based. If I kind of expand the scope of availability beyond merely express entry or a job offer. So I think that was the question for that. And again, any more questions, please feel free to let me know. And in this kind of forum, some people tend to come with like a very particular personal issue, which is understandable, because that's in a sense why this kind of venue is available. It's also to broadcast our expertise at our law firm, just to show that we want to provide some kind of nominal service to demonstrate that we have the required expertise for most any kind of immigration case, including the complicated ones, such as the enforcement or the dealing with the refusals of cases, which tend to be the type of cases that we get because people do what I mentioned before, these discretionary applications like visitor visa applications, and do not realize that there is some facet to that application that may trigger a refusal. The other concern about the increasing refusals is why there are increasing refusals for temporary applications. This has been a pattern since 2021. And part of the reason is the use of artificial intelligence, where because of the sheer volume of visitor visa applications and study permit applications, and in some cases, work permit applications, officers cannot read everything that is being presented, so they employ artificial intelligence to summarize what has been submitted in support of the visitor visa or study permit application. And then based on the summary, rather than looking at all of the documents, the officer makes a decision. This tends to happen if there's something slightly unusual leading to the recommendation to refuse effectively. It's for that reason that obviously if you knew there was something of a negative profile to your visitor visa case, you probably would have filed the visitor visa with professional help from the beginning. But the shortcoming and the reason you're not aware of this is because the immigration website doesn't really talk about the various spectrums of refusals or profiles presented leading to refusal. They simply give you the document list and the forms, and it's up to you to know if there's something that might be an aberration leading to this kind of almost knee-jerk refusal by visa officers assisted by artificial intelligence, which put too much of a focus on the unusualness of the case and or maybe failing to consider the reason for the unusual nature of the case, such as maybe a visitor visa refusal in another country. For that kind of situation, a visitor visa application would be better served by a written submission letter by a lawyer explaining the circumstances surrounding something like that, a refusal in another country, um, or maybe some kind of scrutiny or denial of entry to another country, things of that nature. So, um, with that in mind, we're running a little bit short on time, and I still have some availability for any other questions at this point, because the sort of default that I have when people do not answer questions is just the points of caution, which may give you pause to address whether or not maybe the particular case you are thinking about might be one subject to being characterized as part of an aberration, and this thus leading to a kind of refusal. So, with that in mind, the other big issue, aside from this type of AI based refusal, is the delays to applications, and those delays are sometimes due to the client themselves, where they file a package of documents with IRCC, and then IRCC will return the application after 3 or 4 months saying, well, you missed something. You missed a photograph. Um, you didn't answer all of the address history since the age of 18. There's a gap. And then you've lost 3 months of processing time. The other more frustrating scenario, that's already frustrating, but the other one is you're simply waiting for, well, particularly, well, this could be for any kind of application, a visitor visa application, a permanent resident application, where you filed the application, you've got the acknowledgement, and you've maybe even been instructed to do a medical. Because the processing time has elapsed or more than 1 year, you may have been instructed to do another medical and maybe an additional police clearance. And then there's a problem, because then you're on this merry-go-round of doing repetitive documentation and nothing is moving. In many cases, not all, but many, sometimes this relates to whether there is an issue with admissibility not just for the obvious, like criminal or medical, but inadmissibility maybe because you fit a profile of somebody who maybe is associated with a government that committed human rights violations as a senior officer, or you may have been a soldier in a government who were engaging in human rights violations at the time, or you might have been a high-ranking official in the intelligence or things of that nature. Or simply, you just have the same name and date of birth of somebody who's in that situation, which I've seen. And in those cases, the immigration department is stuck because they're getting information from another government agency, perhaps Canada Spy Agency, CSIS, or another external agency to Canada, which is in contact with CSIS, that this person may be inadmissible or may otherwise be a threat to the safety of Canada, or maybe a spy. And the immigration department's hands are tied in that situation, because all they would have in their government notes is that, yeah, we're waiting on this department. And they don't follow up. So in that situation, the case will never be decided, in which case you have the option for what you might have already looked up online, which is mandamus. And the mandamus is basically just to compel, through federal court decision-making, the rendering of a decision on the relevant application, be it visitor visa or permanent residency, as the case may be. It's preceded by a formal demand, which has to be given to the immigration officer, because there's the off chance, if you compose a formal demand in compliance with the criteria for mandamus, that the officer might say, oh, well, okay, well, they will contact the security agency, and the security agency will get back to them and render a decision. But if that does not happen, then if they ignore the formal demand for a decision, then you have to proceed to federal court. And if the delay is obvious or egregious, sometimes the federal court can resolve that issue through the opposing lawyer's initiative, by their realizing that the delay is unreasonable and without justification, rather. And that could be maybe 3 months from the start of the case. By contrast, in other situations where there is a legitimate concern, the case may have to drag on at the federal court, leading to a hearing, which may take 8 to 12 months of time from the date that you received the lack of response to the demand letter and initiated the federal court case. So that's a common across the board issue with any type of application if you fit a certain kind of profile. Again, when you read the forms and the online guide, they don't tell you this. They just ask you, have you been a senior officer? This sort of thing. And if you do write yes, they may look up the history of that military's activity and look at when you were serving and try to make a determination or express the concern that you might have knowingly participated in human rights violations or things of that nature. So something to keep in mind, which is the reasons for delay. So nothing further. We're coming up to a few minutes left in this webinar related to immigration law. So the other broad point of concern for people, aside from these policy-specific programs, I mean, you could think of, for example, the one for Ukrainians. They had one to expedite work permits, and now they have one to facilitate permanent residency for Ukrainians. There's a minuscule program for people from Gaza, 1,000 people. It has baroque, frustrating requirements which don't look like they can be realistically met from what I hear. There's another program for permanent residency for people affected by the military and political changes in the Sudan, which was announced and is going to come out in the next couple of days or so. And these are, again, policy-based, time-sensitive programs. So they're not strictly embedded in the IRPA or the regulations, but they're creatures of policy. And they have their own idiosyncratic requirements, the most idiosyncratic arguably being the ones for a Gazan temporary resident status in Canada, where they have to disclose social media history and tattoos, and that level of scrutiny is often associated with border enforcement as opposed to immigration. So that means there's a lot of flexibility in how they compose these policies, and they can make them subject to much more scrutiny, the candidates applying under these programs. Arguably more scrutiny than the norm for temporary status for people fleeing politically unstable countries. So that's again done with presumably with some specialized expertise to justify the microscopic differences in policy, which may make it extremely hard for people to take advantage of these policies. So that's another example of the power the immigration department has, which can, in some senses, override the thrust of the law and regulations that were passed by Parliament, which leads to the concern about whether these policies are really reflecting the will of the population of Canada. So it's more of a political question, but because there are political elements in immigration law, this is why you have these kinds of policies, because they're meant to respond to things like international instability and economic changes inside of Canada, hence the sudden, abrupt changes to the study permit program, leading to a lot of chaos if you were just about to file your application. Now, you can't file it until you get a special letter from the institution you're studying at, and that letter is not even available. So there's a de facto pause on processing study permits. Again, study permits are described in the law, but the policy has curtailed the law for now. Again, so it's a question of the sort of uh, extreme amount of power and strength in policies uttered by the minister, sometimes on a short ad hoc basis, sometimes suddenly, wreaking havoc with people such as those trying to apply for a study permit right now in Canada. Hopefully, this will not affect much longer other festering issues like the pause on the parental sponsorship program. Again, that was paused by policy. So parental sponsorship is a concept in the law, but unless you had a profile in the 2020 year, you cannot file for permanent residency for your parents. There is no invitation for submitting an express request to have your parents as part of the lottery in 2021 onward. So another example of the arbitrariness in effect of these policies, which don't on their face cohere with the fact that there does exist, as strongly embedded in the law, family reunification and the sponsorship of parents. So again, it's a little bit of the political aspects impinging on the existence and viability of these policies under the guise of these euphemistic terms such as pause of this program, things of that nature, which again is frustrating those people who want to sponsor parents, for example. So again, that's a bit of the political aspects impinging on the immigration policies of Canada. So that was sort of bordering on a little bit of editorializing, but it is frustrating as an immigration lawyer when we suddenly hear these policies after we've been hired to file for a study permit, and then we have to break the news to the would-be study permit holder that it's impossible to file right now. And this does lead to distortions in the law, where if you cannot sponsor a parent, then if your parent is here for a number of years, it makes other avenues more tempting for bringing your parent here permanently, such as a humanitarian and compassionate application. Again, it's one of those very discretionary applications. So in a sense, sometimes these pauses lead to the motivation of clients to pursue a different avenue. That different avenue is a much more labor-intensive one, namely the highly discretionary, document-heavy type of application, like an H and C, humanitarian compassionate, which takes a lot more effort to assess on the part of the officer because you're dealing with vague criteria and you have to conduct an individualized assessment of the application as opposed to merely assessing, is the sponsor the son or daughter of the applicant, and does the sponsor have sufficient money to support their parents? A very simple, almost objective yes or no type of assessment. So in terms of the amount of work that may be saved by having a pause on things like parents, it remains to be seen. But there are certain consequences when you have a strong relationship with your parents and get frustrated, then you would be motivated to explore these highly discretionary options, leading to perhaps still more work on the part of the immigration department, leading to delays and things of that nature. So, again, this is sort of the intersection of policy having an effect on people's motivations and avenues when they are really concerned about their loved ones, such as elderly parents. What are they going to do? And then they pursue these avenues instead. It's analogous to the phenomena where a lot of students who could not graduate, they try to do a humanitarian case. And again, it's a very highly discretionary application. And unless there's something compelling in the circumstances of that student who no longer studied, maybe something compounded by their inability to return. Again, this is getting very specific to elicit some kind of sympathy on the part of the deciding officer. Then it's very, very challenging for a young, able-bodied person to file for a humanitarian application unless there is something unique, such as some kind of presence of a close relative in Canada that needs them, or some other type of circumstance which would arouse some kind of sympathy on the part of the immigration officer to grant humanitarian grounds, and also grant humanitarian grounds on the basis that that candidate, that student, would be economically independent if granted permanent residency. So again, that could be the potential fallout of the sudden change in the study permit regime, where there is no longer the ability to get a work permit for certain candidates unless they're going to be at the master's or PhD level studying in Canada. So again, that's sort of the echoes of how the law can affect the individual circumstances of a person's plans, and those circumstances could be jarring and sudden and extremely stressful if they've already arrived in Canada and cannot comply or adapt to the changes imposed by a sudden policy change. So with that in mind, given the passage of time, we're at time. Thank you very much for attending this webinar. I hope it was of some utility. And you can reach out to us at www.chaudharylaw.com. You can shoot us an email at clerk@chaudharylaw.com. You can phone or text us at 416-447-6118. And with that, enjoy the rest of your evening. Bye-bye.